In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place at the town hall at 7:30 p.m. on Wednesday, December 18th, 2024.
Corey Villa.
Here.
Allison Canfield.
Here.
Michael Cohen.
Here.
Debbie Nevis.
Here.
Frank Sacamendi.
Here.
Srini Vijay.
Here.
David Cosgrove.
Here.
Gaston Halbert.
Here.
Beth Sol.
Here.
Thanks.
Thank you. We have two sets of minutes to approve before we get into our application process tonight. The first one is the meeting minutes of October 16th. Were any comments received to you, Eileen, or any corrections? No. Okay. Anybody have any last comments? I move to approve the minutes of 10/16. Do we have a second?
Second.
All in favor? Aye. Opposed? And assume any not in attendance would recuse. Meeting minutes of 10/16 passed. Meeting minutes of November 6th were also circulated. No comments on that as well, Eileen? Okay. I move to approve. Do I have a second? Second. Deborah, thank you. All in favor? Aye. Opposed? And also anybody not in attendance would recuse. Meeting minutes of November 6th were passed. We're joined tonight by new counsel, who is just a colleague of Mr. Warner's. I can allow you to introduce yourself.
Sure, absolutely. Thank you, Ms. Sol. Hi, everybody. My name is Chris Sobieski. I'm the acting board attorney tonight. I work with Steve Warner at Savo Schalk over in Somerville. Nice to see all of you. I actually used to go to Seton Hall University, so I drove through Melbourne a lot in my younger years. So hopefully, thanks for having me, I guess.
Great, welcome back. One order of business, Mr. Sacamendi, as you were not here at the last meeting, you have attested that you have watched the meeting, so you're all caught up on the application in its entirety.
Yes, that's correct, and I signed.
You've signed as such.
Which I did notarize as well. So
Great. Thank you. I wanted to read that in for the record. Also for the record, Sujatha Shah is with us tonight. And similarly, welcome Sujatha, sorry for calling you as you're arriving. Just wanted to also ask you, are you also able to attest to the fact that you have watched the meeting minutes or the meeting in its duration from December 4th? Yes. Okay. And we will similarly have you sign and we'll notarize a form saying such. Okay,
Awesome.
Thank you. All right, fantastic. So we're going to move into our application for the evening. That's application 24003, the matter that was carried from our most recent meeting for the fourth time on December 4th. And I see him kind of stalling a little bit for council. But I believe where we're going to begin tonight is a continuation of where we left off, which was we had witness testimony from Rabbi and was asked questions by the board and professionals. And I believe we're moving into a public question session for that witness. Good evening. Yes.
Notice there's no stenographer?
There's not a stenographer, thank you. I also didn't mention that tonight. What you see, this box right here, sir, if I could ask you to explain what it is.
I'm recording the audio for the court report.
So on behalf of the court reporter, his associate is here tonight making a recording but not doing the stenography. So thank you for that observation and
If
clarification.
a transcript is needed, he would be able to do it also.
Madam Chair, please, also clarification on Graham's comment and the attorney was going to get with the applicant about the 50 people
Yep,
portion. So that was never finished prior before public comment. That
before
was
we
the
get to
next
public
step,
questions?
yes.
Great, okay. So we will allow council to give an opening statement and then perhaps if you're able to address that. Thank you.
Yes, absolutely. Thank you very much. Good evening, Michael Levine with Fox Rothschild here this evening on behalf of the applicant, the High Center for Living Judaism, Inc. The chairwoman was correct in her basic summary of kind of where things left off the last time. I think there were two open items that we were going to, when I say we, I mean on the applicant's side of things, going to discuss and circle back to this evening. One was, the extent to which tonight was some sort of deadline for taking action, whether or not there was going to be a further extension. Obviously, we're not in a position this evening to conclude the proceedings. That's very clear. So rather than have that be a lingering question or issue kind of in the background of things, I want to make it clear up front that we'll be proceeding this evening. We'll cover as much territory as we can. And the applicant does consent to an extension of time to take action through January 9th, which I believe is your next public hearing. You'll probably be doing a reorg. And probably at that time is when you'll be scheduling the further hearings throughout the remainder of the year. But yeah, so I want to make that clear up front so that that's not kind of a lingering issue.
Appreciate it.
you,
The second one was what the chairwoman touched on with regard to the traffic study and the enrollment of the preschool, and we had discussed condition. My understanding, and certainly we've got the consultants here this evening that can correct me if I'm wrong. My understanding is there has been some constructive dialogue back and forth between the board's consultant and ours with regard to that general issue and how to best kind of study and capture the potential impact of that preschool and those preschool activities having to do with traffic generally, but in particular the intersection of the realigned driveway that we had agreed to with Park Road. And there's been some discussion about the best way to handle that. ITE, the Institute of Transportation Engineers, has a methodology for trying to calculate the impact of traffic with regard to preschools that's tied to the square footage that's devoted to that particular use. My further understanding is that if you're going to use that methodology, you also have to have a fuller understanding of whether or not there's going to be staggered start times, whether or not there's going to be staggered leaving times, whether or not there's going to be full day programs, half day programs. Those all kind of have to go into the analysis of how best to capture those traffic impacts. So those discussions are ongoing. I think ultimately, both the board and the applicant is comfortable with the notion that there should be some sort of condition so that the board can have comfort that the traffic study was accurate, kind of captures the anticipated impacts, and if there's some change to what we're presenting to you, that would require further approval. The applicant still maintains that that's appropriate. I also think it's very wise that prior to taking any final action on the application, that condition be reduced to writing and circulated and discussed so that there's no misunderstanding as to what it says, what it doesn't say. So that still very much part of the equation. It's just in the relatively short period of time we've had from the last hearing, that process is still kind of ongoing. So I'm not prepared to present specific language this evening. but we're still working through that process, and it will definitely be a part of the equation before everything's said and done.
Okay, so if I heard that correctly, your, the experts will be working with the town's
Absolutely,
expert. You'll be drafting language which the board
Yes.
will be able to review prior to any vote taking place.
absolutely.
Okay, Allison, that answers your question.
does.
Great. Thank you for addressing that.
Sure.
Thank you, Council.
Any further questions on that matter? Okay, thanks.
Okay. So as was said,
I just had
Oh,
a
sure.
question, related, and if you're gonna get to it, fine. I know that our traffic engineer had made some further suggestions after reading the report that we got late before the other meeting. I don't know if you plan to address it tonight or whether we're gonna address it up front before getting to the witness.
yeah, quite frankly, we were really focused in on the other issue that I just kind of discussed, the population and the condition, the best way to address that. I don't recall there being anything particularly problematic in the reply memo, if you will, that Joe put together. But we'll certainly confirm that tonight if time allows, and if not, next time.
You know, I would agree with your characterization. It seems like just sort of
Yeah,
little
right.
things, so.
That's my recollection as well, yes.
Okay,
So again, I think we'll have to recall the rabbi. We'll remind him that he still remains under oath. He responded to questions from the board and the board's consultants. He has not, I believe, responded to any questions as of yet from the public. So that, I think, would be the first item of business. So Rabbi, if you could step forward, please. I will remind you to remain under oath from the last time.
Yes.
And I know I need to make way. Have you been able to, I've been trying my best to kind of stay seated. Originally, I was kind of coming forward in order to make sure I was close to the mic and be heard. Am I being heard okay, staying seated and kind of giving members of the public a little bit more?
Do we have a second mic if necessary?
We do have a mic.
Okay.
It picks you up.
Okay.
I think it picks you up. Okay,
Yeah, having watched the last meeting on the video, I can attest.
you can attest that you
It's
can
fine.
hear him from there. Okay,
Okay.
then that's fine.
Okay, good.
Thank you.
Yep.
Welcome.
Thank you.
So before we begin, I'm just gonna recontextualize if it's anybody's first time here. I think I see some familiar faces now. You're invited as members of the public to come forward. And you would just come up one by one. If you choose to wait in line, you can. I will continue to ask people if they would like to come up. At this time, you can ask questions of the rabbi that should be based on the testimony which he provided, which I believe included some historical and predominantly operational description of the proposed use at this property, the subject property. And then I believe council had a legal question about representation.
Oh, right. We received, Madam Chair, we received an email from an individual by the name of, I'm sorry, her name was Nicole, I just want to get her last name. Nicole Dory, is she here?
Yeah.
Ms. Dory, would you like to approach, please? As I understand it, Ms. Dory is representing an objector group by the name of Sustainable Development for Milburn Township. Madam Chair, one of the reasons we bring this up at the outset of this evening is because if the party is represented by council, the MOU requires that any questions that that party wants to have asked on the record have to come through council. Most parties are still able to put comments on the record, but questions have to be through their attorney. So, Ms. Dory, if you'd like to enter your appearance and
Yes,
take
and
it from there.
good evening, Mr. Oriski and Madam Chair and members of the board. My name is Nicole Dory. I'm with the law firm of Connell Foley, and I represent Sustainable Development for Milburn Township. And I do understand that rule, and I am the only one here that's here to speak for that entity. So my client understands that that I represent him.
Do we need a list of the
Yeah.
members who are clients?
So, Ms. Dory, for this evening, we'll take it that nobody you represent will be asking questions, correct?
That's correct, yes.
Okay, we would still request the list of your clients, well, people falling under that banner, so we know if they do come up to ask questions that they should be going through you. Is that something you'd be able to provide for us? Maybe not this evening, but, you know.
I have to take it under advisement and speak with my client, but.
Okay. Counselor?
If I may, I mean, at some point, I think we all agree that that needs to be disclosed. I mean, the name of the blanket entity, just it's in the same way that the applicant has to disclose the 10% or greater owners, behind
Correct.
it. I think the same would apply here. And I don't know why it would be a hardship or not possible to disclose those names now. Otherwise, we could eventually be hearing from a lot of these folks that we come to find out later, oh, they are represented, in which case the cat's out of the bag, if you will.
He raises a good point, Council.
Yes, and you have my word that I have given that instruction to my client, and no one else will be speaking for this entity besides myself this evening. I'll discuss your request with my client, and to the extent I can, I will provide that list.
Okay. Mr. Levine, would you oppose to proceeding this evening, allowing her
I have not heard an affirmative
commitment?
commitment to disclose that, which I think is a threshold issue before she should be allowed to participate.
Frankly, I do have to agree with applicant's counsel on this one.
Well, I'm not aware of any case law requirement in that regard. It was first brought to my attention by Mr. Warner at the last meeting that he wanted a list, and I told him that, I had instructed my client that I would be the only one speaking on their behalf. So, he didn't think it was an issue. So I haven't.
You said Mr. Warner didn't think it was an issue?
Yeah.
I have to
I know.
disagree with you on that.
I mean, I didn't think it was an issue based on my discussion with him. I don't know what he thought, but he didn't require me to do anything at the last meeting. So,
Well, as I understand it, you didn't enter your appearance at the last meeting. This is your first time.
well, I did introduce myself. So, I'd like the opportunity to speak to my client about it, but I can, are you going to let me speak tonight if I
Certainly
can't
you're allowed
make
to
the-
ask questions. And I
Okay.
think the concern is if, people that you represent want to also ask questions, duplicative would be violative of the MLUL as well, and that's what we're trying to avoid here. So that's kind of why we would like the verification that,
Sure. Right, and I'm just telling you, as an officer of the court, that I will not be letting my client speak on my behalf or on behalf of this entity. I'm the only one that was speaking there this evening.
On behalf, you keep saying on behalf of the entity, but it's the people that are, no one's going to speak on behalf of Sustainable Millburn or whatever it is. They're going to speak based on there are people behind that are likely to be neighbors of the development. So when you keep saying the entity, that's a little questionable to me. It's really the people who comprise that entity that I think I'm concerned about.
is right.
That
Right,
said, if
and-
there's no established case law on it, I think at that point, an objection could be noted, right? But if there's no established case law, then I don't know if there's a hard and fast rule that has to be disclosed, right?
It's certainly the MLUL does have a specific definition as to who constitutes an interested party. That's a defined term under the MLUL that has been the subject of interpretation. And again, that's kind of a threshold issue. Interested parties that have a established meaning have the right to participate in these proceedings. So until we find out who that person is, their proximity to the subject property, their involvement, we can't determine whether or not they're an interested party as defined under the MLUL with rights to participate in such a direct manner.
Good point by applicant's counsel, Mr. Lord.
Well, as the board member did note, there is no established case law on this, and I can represent you to that my client owns property in the municipality. They're within 200 feet of the application, and they have standing to object to this application.
I understand, but until we know who exactly your client is and who forms your clients, it's very difficult. I hope you appreciate the position we're putting here. Would you like a chance to maybe discuss with some folks?
No, but I can tell you that I don't see any clients here this evening. I'm the only one here for the entity. So the people in this room, they're not my clients.
Okay. Counselor,
There's a lot of faces that are missing that have been consistently at the last few meetings.
Mhm.
I've noticed there's a lot more empty seats. So, I don't know if this is something that you should unilaterally decide. If you have to, maybe the board should vote on it.
I'm just trying to field some arguments, but yeah, point noted. Applicant's counsel, Mr. Levine, would you object to allowing her to ask questions, but the representation she offered, or what do you think from you?
So I do, my objection stands. I don't withdraw it. If the board feels it's appropriate for them to make a motion or vote on it, that's certainly within your prerogative. But, I've explained that my reasoning and that objection does still stand.
Okay. Well, I guess I'm not the decision maker. I'm just trying to field some answers and advice.
I appreciate it. And Mr. Ray, I just want to clarify, just because you made a comment to it, you did introduce yourself at the last meeting. At that time, Mr. Warner said, if you are to speak, we do need you to furnish a list. And you heard that. And then we said, well, we'll sort of cross that bridge, thinking you were going to be potentially speaking at asking questions at our last meeting. When you didn't, the issue hadn't arisen. I think the anticipation was that if you were to come again and appear again, which you are and you are entitled to, you would be furnishing that list. That was how I interpreted his request.
Okay.
So I understand if you didn't, but I just wanted to clarify that because I heard it as well as you introduced yourself.
Well, that said, we're here now, and, you know, we're trying to keep these proceedings moving in a timely fashion, right? So if we have to make a decision on this, then, you know, I'm happy to make a motion to go to a vote, but we need to come to some sort of conclusion as to whether this board is going to allow, you know, the attorney to continue.
Agreed. Okay.
You know, I think as an officer of the court, you know, if she swears and attests to the fact that none of her clients are here in the room, that should be good enough
She
for
hasn't
tonight.
said
She
none of
hasn't
her
sworn.
clients. She said her client, the entity. She has not said none of her clients.
None of my clients, none of my clients. There's no person here that I
That's a
represent.
part of sustainable
Correct.
numbers.
That's pretty clear.
That's different.
I think she's made a representation as an officer of the court that, and she's attesting on oath, under oath that her clients are within 200 feet of the applicant property, which would give them standing as an interested party, so.
Just to clarify, and I do apologize if I missed it, I don't believe this woman has been placed under oath as of yet.
Correct.
She's not been placed under oath.
So
It's
let's
just-
let's place her under oath and we can ask.
Mr. Story, would you
Make
be,
those
would
representations.
you be willing to swear under oath that nobody you represent, nobody affiliated with the entity you represent is present this evening when we ask them questions?
We put her under oath first.
Nobody will be asking questions except for me. Yes.
Yes, to what I asked.
Yes.
Correct. Okay. All right, well, might as well, if you're offering, might as well. You swear affirm what the testimony you offered and any testimony you would continue to offer, you know, in this capacity, is the truth, the whole truth, nothing but the truth.
Yes.
Okay.
I'd also feel more comfortable if you did, on the record now, affirm to the fact that your clients are within 200 feet of the applicant property and have it, and thus are interested parties.
Yes, my client owns property within 200 feet of the application and has standing to object to this application.
Well, your client, Sustainable Development for Milburn Township, is that entity owns property or someone who's affiliated with that entity?
Yes,
owns
someone
property?
who's affiliated with that entity owns property.
Okay. Is it one individual? Is it multiple individuals? Are you at liberty to?
But I'm not at liberty to say that right now, so.
Okay.
Okay, if you'd like to put forth a motion, I think we can take a vote if we are willing to have Ms. Dory represent Sustainable Milburn in.
Well, allow her to ask questions this evening without receiving a list from of her clients.
Yes, certainly, I think it would be good for her to confer with her client and get this resolved more fully before the next meeting, but in the interest of keeping things moving along and making sure that everyone has adequate opportunity to question the witness, the rabbi, you know, I think we should allow her to proceed tonight. So I'll make a motion that we vote to allow the attorney here to proceed to ask questions tonight on behalf of her client or clients. And she's already stipulated as an officer of the court sworn in that none of her clients are present here tonight and that they have good standing. So I make that motion.
So clarification, is it conditional on her providing the list to us in the next meeting?
I would recommend that it should be.
I don't know that we can do that because if there's no established case law on this, you know, I don't know that that's a requirement.
I have a question. Can you also clarify that your client, is it a corporate entity
It's an LLC.
and it does not own the property? It's
It's
the
members.
So, and none of those people are in the, none of those members are in the audience.
Okay, there's one member. It's a member, okay? It's one member.
Meaning the entity is one member or there's one member present?
There's one member in the entity and they own property.
Okay.
Who is present?
No, who's not present.
Okay,
I could have sworn you just said.
I- you did, yeah.
Yeah.
I'd like to second that motion. I think, you know, it's very clear that the client is not here. It's an LLC and I would like us to keep moving.
Okay.
So,
Is that-
We've had a motion made and seconded, and is that with the stipulation that they will provide the list? Or you're saying no?
Again, I don't think that we have jurisdiction to do that.
Okay.
So
So it's without stipulation for the list, that's what the motion is. That would,
And are we gonna be in violation of anything should we proceed? Like,
I don't believe so, quite frankly.
I don't believe there's any board rule or any case law that addresses this at all or requires this.
So council, I just have a question because I think there's a distinction in that the LLC does not own property, so technically it might not be an interested party. While the individuals are, the LLC is not.
right.
Right. Well, regardless, I mean, the public, broadly speaking, has a right to ask questions, and, you don't need to be an interested party in order to be allowed to ask questions,
Okay.
right? But nonetheless, I'll throw to Mr. Levine, are you aware of any case law that would require a list to be provided? I can't say that I am off the top of my head.
Not off the top of my head in terms of a list, but certainly a disclosure of some sort. I know it has to be a written list, but I'm sorry, just as a point of clarification, I thought it had been asserted a number of times by the officer of the court that there were no members, no clients here. I thought I just heard, well, yes, there's one client here.
That's why.
why I
No,
asked for
I didn't say
clarification.
there's one client here. I said that there's only one member. There's only one member.
client.
of
Okay,
this
there's one
LLC.
client, one member.
Okay.
We all heard present, so
I
I think
didn't,
that
I
was.
don't see them here.
So
Okay?
just again, to be clear, so you're representing the entity and the entity has members and some of the members, I guess, are clients, but other than members might not be clients.
There's
a-
It sounds like there is one member in the
That owns
LLC.
property.
The LLC has retained this attorney as counsel, and that sole member of the LLC, we have heard testimony, is not in the room.
Okay, can we take a roll call? Yes. Okay.
I was
There
gonna- I was-
a motion and a second.
Yeah, my apologies. I was just before the board votes on that. Another thought I had. Ms. Story, is there any chance you'd be able to speak to your client over the phone and get, request to, to
Okay, I
disclose
can
his or her
try to do
identity?
that.
Okay.
I mean, am I gonna be able to ask questions tonight or?
I mean, do we need to take a 5-minute recess so that
Well,
we
you
can
can
get
call
this?
your-
But in the effort of trying to keeping things efficient, making good use of our time, I'm sure there's a host of other folks here that have absolutely nothing to do with it.
I was gonna
that
suggest-
are eager to have the opportunity to ask their questions. I'm
Right.
sure that can proceed, and however long it may take to reach the client in the hallway, that can.
I would like to be part of the hearing, so, I mean, if there's, you were about to take a vote, I guess, I mean, I'd like to ask the questions.
Well, Ms. Story,
I
to
think
be
it's
fair, you were advised by
reasonable.
Mr. Warner we requested this list, several weeks ago.
No, he didn't request it of me, he said that we would deal with it, and I didn't understand that
He made
he
the
meant
request.
that he would request it. I guess you did, because you've worked with him for a long time, but I haven't met him before, and I introduced myself, and I said that I did not intend to disclose my client, so, he said that we would deal with it, and I told him that,
Well, we're trying to deal with it right now. That's kind of the problem, right?
right,
So, I mean, that was
Well, so
clearly passed along to
Even
you.
in the event that the client says no, they're still within their legal rights, given that there's no case law on this, to proceed. So if we actually fail to allow this attorney to represent the interested party, then, couldn't we as a board face consequences for that, right? While both, while one side can object, so too can the other, and that could cause legal problems.
Well,
So
we don't know that the LLC is an interested party because the LLC doesn't own property, but from what I hear from our counsel, that's irrelevant.
well,
It's
Anyway,
irrelevant,
but
it's
it's
certainly,
question, so.
may I be heard? The fact that one of the members owns property could provide standing for the LLC, so, that's enough. It's
So
not
there are
relevant.
multiple members. I thought you said.
No, I
there
said there's a sole member and they own
You
property.
said none of them, you keep.
One of the members, she said.
So one of the
That's how you
members
phrased
owns
it.
property, but there are more,
I'm
there's
the
more
only
than
one who's
one
speaking for
member.
the entity.
There's more than one member affiliated with Sustainable Milton.
No, I said it's a sole member, sole member.
Sole member.
That's your
She
testimony.
said none of the members,
Members.
yeah, she again said members.
Because
That's
when
very,
someone's referring to an organization, I would think you would generally refer to the organization as a plural, not a singular. So, I mean, I think right now we're arguing over semantics, and that's
Well,
irrelevant.
because they're not
We've heard-
participating in the
We've heard
work.
testimony that there's
Okay,
a sole
so we can take a
individual
vote
in
then.
the LLC.
So the motion has been made to hear this attorney on behalf of the LLC, and we've had it seconded.
Corey Biller,
Yes.
Elsie Testor,
Yes.
Michael Cohen,
No.
Deborah Nevis,
Yes.
Frank Sagamendi,
Yes.
Sujata Shan,
No.
Srini Vijay,
Yes.
David Cosmo,
Yes.
Gaston Halbert,
Yes.
that's all.
Okay, so we will hear you too.
Okay, thank you, I appreciate that. Good evening, Rabbi. May I call you Rabbi, sir?
Sure.
My name is Nicole Dory. I'm the law firm Connell Foley. I don't know if you remember me. I heard your testimony at the last meeting, and I'm trying to better understand all the uses that you're proposing for the property at 165 Old Short Hills Road. I understand you're proposing a house of worship with the nursery school and the Hebrew school as well. Is that right?
Yes.
Okay, and I heard your testimony at the last hearing, and you were explaining your current operations at 1 Jefferson and then how those might be transferred over to the 165 Old Short Hills Road property and maybe expanded also. Is that right?
Yes.
So for the house of worship, you're presently operating a house of worship at 1 Jefferson, correct?
No.
No, what type of services, I guess, or
We
religious
were just
services are
talking about the proposed application. So you're asking what they do currently at a different site. We're just asking about the use of the proposed application.
Right, but in his testimony at the last hearing, he was referring to the operations at 1 Jefferson, explaining what the operations were at that property, and then saying that if the application was approved, those operations would stop at 1 Jefferson and then be transferred over to 165 Old Short Hills Road. That's what I heard from his testimony at the last hearing.
Was that
Was that
your testimony?
Was that your testimony, sir?
Yes.
Okay. So I'm asking him about the operations
those
that he's presently having at 1 Jefferson, so I can understand which of those are being transferred over to 165 Old Short Hills Road. Okay?
Sure. Okay. So Rabbi, you can answer the question of what of the
was the
operations that
question?
happen at Jefferson, as you testified to, would operate in the proposed building.
Oh, our religious services.
Okay, I just wanted to clarify some of that, because you said you weren't operating a house of worship at 1 Jefferson, but what I understand is there's what's known as the Chai Center Shabbat, as advertised as operating at 1 Jefferson, and that's.
Is counsel being argumentative?
She
I
can
just said
ask the
no.
question.
I said, no, my answer was no.
Okay.
We're not running a house of worship, and it seems like you're being argumentative.
Well, I'm not trying to be argumentative. I apologize for that, but I looked at your website, and I have a copy of it. I can admit it to the board, and it's a website for the Chai Center Shabbat. Anyone can find it through Google search, and it does advertise services being conducted at 1 Jefferson in Short Hills, and I want to know if those same services are going to be happening at 165 Old Short Hills Road, and if they're going to be expanded, and I wanted to ask questions about that.
Right, and you just said, when you asked, I'm just making sure I'm following the
A little
conversation.
confused about the
When
question.
you asked what activities happen at 1 Jefferson that would be transferred, I believe you said worship,
It's a worship service.
worship services. So then I thought your follow-up question was, do you have services? So he had just testified, yes. I'm just making sure I'm understanding your question.
Do you have services other than religious services at 1 Jefferson currently? Are you?
I don't understand the question.
What type of religious services are you offering?
Other than
at 1?
religious services, do we have other religious services? I'm not understanding your question.
Okay, do you presently offer daily prayer at 1 Jefferson?
Those are our religious services, and we don't offer daily prayer. We do offer prayer, and that's our religious services, yes.
And you offer daily
Is counsel
prayer?
being argumentative?
She's not being argumentative now, she's asking for clarification.
If I may though, I think what might be more directly relevant and pertinent and a more appropriate way to pursue this line of questioning, which is certainly fair, is to have the rabbi itemize those proposed activities that he proposes for 165 Old Short Hills Road, rather than focusing on an itemization of what currently may or may not be happening at 1 Jefferson, which is not the application that's before the board. If she would like a thorough explanation of everything that's proposed to happen at 165 Old Short Hills, I'm sure the rabbi would be happy to give you the entire laundry list.
I'm also entitled to question the witness, as I would like to, and I'm asking him about the current services offered at the property right next door that he's testified to previously would be transferred over to the property that's the subject of this application. So I think my questions are
Sure,
fair.
but you have asked a question which I know we heard answered during the previous testimony. He attested that daily service, does not happen now. So I did know the response to that from last week's testimony, or last meeting's testimony. So I will allow you to continue asking questions. That's fine. I understand, and you are entitled to. But if it's questions we've already had the answer to, to Mr. Levine's point of what are you going to do in the new facility, I feel that we did receive testimony to that. So if
Yes,
there
I heard at the new facility that he would be offering daily prayer. And at the current facility at 1 Jefferson, I understood that he was offering daily prayer as well.
I will allow him to answer as he just did, but I also heard that it was not daily.
I'm not
That
sure, what was
my
your question?
recollection.
Well, maybe I can ask it this way. At the last hearing, you described a settlement agreement between Milburn Township and the Chi Center that allows operations or religious services at 1 Jefferson. And you said something about the fact that you've been operating there since 2005. Do you remember that?
Yes. Madam Chairman, all of these questions are focused on 1 Jefferson, 1 Jefferson. That is not the subject of this application. Certainly, this application has nothing to do with any prior settlement agreement as between the applicant and the town, which pertains directly to 1 Jefferson.
Frankly, I have to agree with applicant's counsel for my opinion's worth.
Well,
Are these questions directly related to testimony that the witness has given? And so wouldn't it be reasonable to ask, if the testimony was that we have various services that we're offering at one location, they're now going to be offered at this location. I don't see why it's not germane to get answers to that question. It's directly questioning testimony that was made, it's asking for clarification, and why. I don't see why this is such a difficult thing to get an answer of. Obviously the applicant knows what services they're going to offer. You should be able to share that.
Exactly. What services they're going to offer, not what services they're currently offering at 1 Jefferson.
Well, the rabbi has already testified to the long history of this congregation in this township, and there's a settlement agreement with the township that's related to the property at 1 Jefferson, which is right next door, which he's testified to.
We're not here for 1 Jefferson. We're here for
But
165 Shore.
the application has to do with the property at 1 Jefferson. Any discussion of this application must include a discussion of what operations will be ceasing at 1 Jefferson, because the rabbi has made a representation about this as part of this application, that he will return the use of 1 Jefferson to his home as a single-family home.
1 Jefferson is not a part of this application.
But it must be a part of this application, because this board cannot approve an application for a house of worship to exist at 165 Old Short Hills Road if a house of worship is going to continue to operate at 1 Jefferson. Then you're going to have 2 houses of worship. And the rabbi has made a representation to this board at the last hearing that he would return 1 Jefferson to a single-family home if this application is approved. And I think that is very germane to this board's consideration of this application. If this applicant is in fact going to be doubling the use of the property, having uses on more than one property, that's going to affect traffic and circulation. That's going to affect all these things.
So is your question, will all current worship activities from 1 Jefferson be shifted to the new location?
Yes,
in its
yes,
entirety?
that was what my questions were trying to get at, and I was starting to ask some of those questions. And
If I may, Madam Chair, just two things. There's, not that that's what we're proposing, and we'll reiterate, the rabbi testified last time. I'm sure he will testify again in a moment. But there's absolutely no prohibition in the ordinances in Milburn from having 2 houses of worship next to each other, as long as each property conforms with the applicable requirements under the zoning ordinance. There's nothing illegal or untoward or perhaps even unusual about having 2 houses of worship next to each other. Having said that, the rabbi did testify under oath last time that there will be no continuation of religious services and observances of any kind at 1 Jefferson, and it will return to residential use. I will ask for him to reconfirm that tonight under oath. With that being the case, the details and minutia of what is going on in terms of operating as a house of worship at 1 Jefferson now when it's not the subject of this application, would be completely irrelevant and a waste of the board's and the applicant's time.
Frankly, I agree with applicants' counsel.
Yeah, would
Madam
that
Chair.
satisfy the line of questioning that you're trying to understand, which is in the future condition, would the not applicant property be returned to a residential property?
Yes, I would like answers to some of those questions, but Madam Chair, I disagree with your counsel and also Mr. Levine that anything related to 1 Jefferson is not part of this application. We've heard the testimony.
By definition,
Can
this
I finish?
application,
Can I-
you can.
Can I finish my argument? This application and this applicant and this particular witness have a long history. There was a settlement agreement with the township for the property right next door that, this applicant believes has allowed it to operate a house of worship on that property. There's also a judgment in 2014 that prevented the property from being used as a house of worship. So there's a long history with the township and this applicant. And so when this applicant says that it will be returning 1 Jefferson to single-family use, if this application is approved, I would hope the board would make that a condition of its approval if this application is approved. But also, I think it's very important for this board and for the public to understand what this applicant believes returning 1 Jefferson to a single-family home means. Because in the past, the applicant has argued that 1 Jefferson was used only as a single-family home, even though religious services and other events were occurring there. And even though there was a judgment that prohibited certain uses, it continued those types of events. So I think that is very relevant to the board's consideration. And also, I think that the board should be aware of a settlement agreement that was entered into with the applicant and the township in
Ms. Story,
2019.
You brought the settlement agreement multiple times. That is not within the purview of this board. That is between the governing body and the applicant. We are here to decide, this board is here to decide whether or not the applicant has met its burden of proof to an entitlement to site plan approval for 165 Short Hills. Not one, to the extent 1 Jefferson may be involved here, I think that's been addressed by the prior testimony already, seems to have been at least. That's my position on it, at least to the board. This is kind of getting far afield of what we're actually legally allowed to consider here.
Well, I've heard your position, but at the same time, this board has jurisdiction over this property and needs to understand from this application if the applicant
This
is
property,
proposing
exactly.
2 houses of worship next to each other or 1.
That is not what
That
this
is
board
not-
is doing.
that
This
is
board
not.
is only.
Right, but I'm trying to question the witness to confirm that because, that
But I
information
believe
wasn't
he's
clear
testified.
from his prior testimony.
Understood, Ms. Story. I believe he's testified that all religious services and observances would be ceasing at the 1 Jefferson property. So
I
I don't
haven't
understand
heard
why-
that. I heard
Okay,
that he
can
would
we allow
return
him
it
to-
to his home. That's all I heard. So I wanted to understand what he meant by returning the property at 1 Jefferson to his home.
So is there a specific question that can you more narrowly define the question so that you can ask it to the witness and have him, affirm or deny? So we
Okay.
can settle that?
Okay, I can try to ask it like that. So Rabbi, can you tell me if this application is approved, would the applicant agree to get a condition to return the property at 1 Jefferson Avenue to use only as a single-family residence? Is
No.
that- No?
No.
And why not?
If I understood correctly, your question, and I'll restate it. And my understanding was, would I agree that the board should issue a condition upon which they would condition their approval for 165 Old Short Hills Road, attach some condition to our use of the property at 1 Jefferson or anywhere else in the world? And the answer is no.
Frankly, I'm not even sure legally the board would have standing to oppose such a condition.
I don't understand your whole ideology. And I will say for the board, I made up my mind I was not going to speak tonight, more than yes or no. But I will tell you that Ms. Story represented 165 Old Short Hills Road. The judgment she referenced, 2014, was solely held by 165 Old Short Hills Road as their.
Excuse me for interrupting you. Are you
She's being
speaking?
dishonest, is my point. So be honest. That's all I'm asking of you. You're an officer of the court, be honest.
Okay, but Rabbi, if you're speaking about something that is from the past, and again, the settlement agreement between the township and if there is, that it is not, that judgment and that decision, while I understand what you're saying, that context could be important, that this board doesn't have jurisdiction to impose any conditions on or weigh in on what is happening in a separate legal.
Madam Chair, I
Matter.
respectfully disagree with your
Okay.
position.
Thank you.
The applicant testified specifically to the settlement agreement at the last hearing. I'd like to introduce it into evidence. I'd like the board to consider it. I have a copy of it with me this evening. I think the board should consider it in connection with deciding this application.
Again, categorically object to the submission of plainly irrelevant evidence that would only serve to dirty this record.
My advice to the board would, that I concur with applicant's counsel, it's completely outside of the scope of what this board is bound to consider, as I just explained.
Well, is it outside of the scope if the applicant introduced it and used it as part of his testimony to, justify the fact that, well, I think what they were probably getting at is there's a certain amount of traffic, right, that occurs at that address as a result of services that are offered there. That traffic is now going to be shifted to 165. If that same amount of traffic is going to exist and not get transitioned over, well, then I think that gives the board more to think about with regards to, what the impact is going to be on traffic. And then that makes you wonder whether the traffic engineering took that into account. Because from what I heard, the traffic engineers were taking into account the change that we were going to have in traffic based on, what they said the proposed use was going to be.
But
I think, thank you for bringing that up. One counterpoint is that the existing base traffic would include the existing facility. And now we're talking about adding on top, right? It would include the existing property that's in the baseline traffic counts, which were undertaken. And then what they're proposing would be on top of it. So
Was
for that reason, I have no
Well,
opposition
maybe
to
that's a
him.
question for the traffic engineer to get clarification as to whether that baseline was included or if it was
I think they subtracted out.
correct.
But again, that's a question for the traffic
Okay, it's
engineer.
a
and it
question for the
doesn't-
traffic engineer, but it
reference-
doesn't reference a settlement agreement and bringing that in. If the crux of your question is about traffic, we can ask the traffic engineer that, and you
Well,
have
I'm
asked him while he
trying
was
to
under oath, but
understand-
presumably your client or entity would have asked questions at that time. So I can allow you to continue asking questions of the rabbi, but I'm requesting that we not ask questions having to do with a property that's other than the subject property. So you've asked about use, you've asked about transfer of the use and what uses would be transferred. I understand that because that reflected the testimony. So
Are you prohibiting me from entering the settlement agreement as an exhibit at the hearing?
I believe so based on legal advice,
I think
yes.
we have to vote on that, don't we?
I
this
don't
is
think we do
not-
have to. Do we?
I would recommend against it, just under the circumstances, again, it has very little.
Yeah, speak into the microphone.
I'm sorry, it is very little bearing on this. And applicant's counsel's objected, I have to concur with him, I don't see how it's relevant to what the board is to consider here.
And what about copies of the 2014 judgment that were submitted with the application? I wouldn't be able to submit that to the board.
These are items that are submitted that were submitted as part of the application, then the whole board has received them.
Okay, so I mean, that's the judgment that I was referencing is included with the applicant's materials. So I just wanted to bring that to your attention. He did testify as to the settlement agreement at the last hearing, but if you're not going to let me introduce it, then I'll ask something else.
It wouldn't need to be introduced as we have received it already.
Well, I'm objecting to the fact that you're not allowing me to introduce that exhibit. I'll proceed.
One more question, so if it's already in evidence, right, if it's already in the application, isn't it fair to ask questions about that, especially when that was specifically brought up and testified about by the applicant? I just don't see why.
Hold on, the judgment was submitted, or the settlement agreement was submitted?
The judgment was submitted with the application. I don't know if the settlement agreement was attached with the application materials.
So, I mean, if the judgment has been submitted, then I suppose the applicant offer that as part of their case, for whatever reason.
Can you confirm that,
Mr.
Mr. Levine, was the judgment submitted as part of the application?
But again, I don't see what the bearing of that judgment is on this particular property, 165 Short.
Can he answer the question
I'm
if it
sorry,
was
yeah,
submitted
my
as part of
apologies.
that?
So part of your completeness checklist requires a copy of title search of all of the recorded easements and encumbrances on the property. So we requested a title search and submitted it along with our other application materials because it's a required completeness item. There is an appellate division decision that was recorded in the public records that renders an opinion with regard to the interpretation of two restrictive covenants. One dating from 1898 that was imposed in connection with the establishment of the Short Hills Association, which was identified and discussed in one of the, I think we're up to 3 now, HPC reports that have been issued that undertook a deed review, is referenced. The other restrictive covenant that was the subject of that decision had to do with a restrictive covenant that was imposed by the prior owner of 165 Old Short Hills Road on one Jefferson and all subsequent owners of 1 Jefferson. That was the second part of that decision. That was also part of the title search. So both of them, the entire decision has to do with the appellate division interpreting restrictive covenants in deeds. With regard to that issue, I think there is case law, and the Cox Treatise is clear that as it pertains to recorded restrictions in deeds, that is a matter of contract between private property owners. It is a separate and distinct issue from what's before the planning board in terms of passing on a land use application and a development application. They're two separate issues. So it was only entered into this case because it was a completeness requirement that we had to comply with. It's not been the subject of extensive testimony. Our arguments in favor of this application do not rest on that. It's a separate issue that's not really within the purview of the planning board, and that is the subject of reported case law. And for that reason, it should not be submitted, or to the extent it's already been submitted because it was a completeness item, should not be the subject of lengthy discussion and question.
Again, Ms. Story, I'm sorry for forgetting my last name. I don't see how that's relevant to, again, what's before the board, whether or not the applicant met its burden of proof to establish an entitlement to site plan approval.
Well, I think it also goes to the credibility of the witness and the applicant. This board has to consider that this applicant has had a judgment against it that has restricted the use of a property, and that applicant has continued to use that property adverse to that judgment. And then also the fact that there was a settlement agreement later entered into by the township trying to further restrict that use because the judgment was not successful. So I think that's very relevant to the credibility of the applicant and for the board's consideration of this application, especially when the witness has testified that he'll be transferring operations from one property to the next. So that's my position.
And I think the way to challenge the credibility of the witness is to ask specific questions as to his prior testimony. Anything beyond that, quite frankly, is an ad hominem argument against an applicant, which is clearly outside of the bounds of the plan.
Highly prejudicial.
Wasn't she trying to do exactly that? Ask direct questions about direct testimony that was given by the applicant.
Yes.
So, Ms. Story, if you could specifically repeat what it was that was testified. I think if you could ask the question about his testimony, I think that would be helpful to give us a crux of, you said this, and I would like clarification on that, which I think is where you began with saying you attested to everything shifting. That helps us as the board understand the questioning. So when you say you reference a settlement agreement, can you be more specific of what component he testified to that you were asking about? Yeah, and reminder to members of the public, we are only having one person speak at a time. Thank you.
This is a quasi judicial proceeding. I think people should be very respectful of that. Thank you.
Madam Chair, I forgive me, but I am a bit confused at this point by the directions that have been given to me. I thought before you were telling me that I was not to ask questions about 1 Jefferson, and now are you allowing me to ask questions to the extent the rabbi has testified regarding that at the last hearing? Is that
I would say if you could bring up what was testified, you would be permitted to ask questions about something that was testified to. So if he brought up something and opened a topic and you had a question to clarify to the extent that he made a specific statement, you can ask a question to that effect. Mr. Levine.
Understood. Just to emphasize the point, and this is exactly what I was alluding to more clearly and succinctly beginning with the last hearing, which is, yes, as Mr. Warner has stated, there are timeframes within which the board is supposed to take action on these applications. It's for the protection of members of the public so that they have a full and fair opportunity to participate. It's also in favor of the applicant to make sure that they have a reasonably efficient and expeditious resolution of their development application. So when we say that there was prior testimony as to the settlement agreement, I think the rabbi mentioned in passing that it exists.
Well, that's my clarification to ask.
So he made a one-off reference in passing that it exists. I do not believe that, and particularly in light of the timeframes that the board's supposed to be observing, I don't believe that that offhanded comment justifies 45 minutes of in-depth questioning about the subject of the settlement agreement that doesn't directly pertain to this property.
Frankly, I agree.
Madam Chair, I've 5 minutes. I mean, I haven't even been able really to ask any questions. I'm trying to be as efficient as
I
possible
understand.
here.
Questions
And I
are
think if
highly
people know me,
prejudicial
I'm
and
a very
outside the scope
efficient
of this
person.
board's
So if I could proceed, then I'm sure we could get through a lot more. But
Thank you. So we will permit you to continue your questioning. Can we ask for everybody to be quiet, please, and counsel as well? Thank you. You can ask questions, as we just have stated, and to answer your question and clarify. If you would like to ask a question to clarify the testimony that was provided, if you can cite what it was versus, if you mentioned the settlement agreement in passing and did not provide any detail about it, then I think to Mr. Levine's point, that was not a testifying to it and all about it. If he mentioned that it occurred.
I'm not aware of any case law that supports that position, Madam Chair, in all due respect. But I have to say that the rabbi mentioned a settlement agreement that he said permitted him to operate on 1 Jefferson. I'd like to introduce the settlement agreement to the board and clarify what settlement agreement he's talking about. That's what was mentioned in his testimony at the last hearing. That's what I wanted to do. But based on what we've talked about for the last bit of time, I don't think you're going to allow me to do that. So I don't want to keep on retracing steps here. If you're going to allow me to proceed, I'll proceed. But if you're going to prevent me from introducing that as an exhibit, then I won't ask about it.
I stand by what I said.
So you're not going to allow me to ask about the settlement agreement or introduce it as an exhibit. Is that what I'm hearing from you?
At this point, I don't think so.
We're being advised not to. I guess, do we as a board want to take a vote? I'm fine to do that.
Probably should take a vote so that we.
I'm fine to leave it to the board's
That way,
decision.
yeah,
So
it's
does
not
anybody want to
subject
move
our
to
decision.
allow this to be introduced?
So I'll make the motion that we allow, the attorney here to introduce the settlement agreement that was directly testified about by the applicant.
Is there a second?
I'll second.
Corey Miller,
No.
Allison Canfield,
Yes.
Michael Cohen,
No.
Deborah Nevis,
No.
Frank Sagamundi,
Yes.
Sujatha Shan, Srini Vijay,
Yes.
Gaston Halbert,
No.
that's all.
No.
Okay, so the no's win. So I will not introduce the settlement agreement as exhibit. I won't introduce the 2014 judgment. You have it in your application materials, so it's part of the record. And I will proceed with other questions.
Thank you.
Based on your direction. So Rabbi, can you tell me how many congregants does your congregation currently have?
We have a very loose congregational definition of congregants. Do you mean how many people attend? I'm not sure what your question is.
Do you have a list of congregants?
No.
Do you know approximately how many?
No, I think I testified that we have people that attend our services, and I also mentioned to one of the board members that he would be welcome to come at any time. We don't have, quote, a dues requirement of any sort. So I can talk about that if you want, but you'd have to ask more specific questions.
Okay, so do you have an estimate of the number of congregants that might increase when your services are moved from 1 Jefferson to 165 Old Short Hills Road?
No,
Do you have an estimate of how many congregants will attend services at 165 Old Short Hills Road?
I based that estimate on what we have today, yes.
And that was based upon the activities that you testified to at the last hearing that were
Yeah.
part of your worship services?
Yes,
So can I just go through some of those and ask you some more questions so I can better understand the uses that are proposed for the property?
yes,
Okay, so you mentioned that you'll have daily prayer services on the property at 165 Old Short Hills Road, is that right?
No.
Okay, are you only proposing to have weekly prayer at the property?
no, what I actually testified to was that we would continue our prayer schedule, which includes Saturdays, Sundays, and holidays. And that I would hope at some point to work up to have daily services, but that we don't currently have them. That was my testimony and continues to be my testimony.
Okay, so your anticipation is that you would have weekly services Saturday and Sunday, is that right? In the
Yes.
mornings?
Yes,
Okay, and would you also have weekly services on the evenings and Saturdays and Sundays?
we don't currently, but that would be my hope for sometime in the future, yes.
Okay, and is it also your hope sometime in the future that you would also have daily services Monday through Friday, also in the morning and the evening?
I think I just said that.
Okay. And do you have an estimation of the number of congregants that would attend those daily services?
Last time I testified, and I stand by that testimony, that we would probably have a maximum of 15, between 10 and 15 people.
And what is the basis of your estimation of between 10 and 15 congregants attending those services? Is that what currently attends at
We
services?
don't have those services currently, so you're asking me about a projection for a service that we don't currently have and we've never had during the old days of the week. So you're asking me what the basis for my projection is, and I can only say that's a projection. So, you'd have to be a little more specific.
Have you considered the size of the building and how many persons could fit in the side of the building to determine how many people might be able to attend daily prayer services?
No,
Did you consider the amount of people that attended weekly prayer services? I think you said on Saturday mornings. Are those held at 1 Jefferson currently?
yes,
Okay, and is it between 10 and 15 persons that attend those current Saturday morning prayer services at 1 Jefferson?
no, my testimony last time was between 20 to 40 Saturday morning. And I stand by that testimony.
So why is it your projection if 40 people, as many as 40 people attend Saturday morning prayer services at 1 Jefferson, why do you anticipate that only 15 persons would attend morning prayer services at 165 Old Short Hills Road?
Because it's the middle of the week when people have to go to work.
So is it your testimony that you anticipate that Monday through Friday, if you hold morning or evening prayer services during those days, that it's only 15 persons that are anticipated to attend those?
Yes, I say 15 on the high side. We'd probably get closer to 11 or 12. And that's, again, a projection for the future.
And on Sunday, there would still be, your projection is 40 persons attending Sunday morning
No, I
prayer
did
services?
not say that.
And what is your projection for Sunday morning prayer services?
The same as a weekday,
The same as a weekday?
yes.
And why is it less than 40 when you're moving from 1 Jefferson to 165 Old Short Hills Road if it's the same day of the week?
I think you're confused. I testified about Saturday morning, and now you're asking about Sunday morning. I can answer the question even though you didn't ask it, and that's Sunday morning. Our services have between 10 and 15 people, and that number would continue.
Okay, and for the Saturday morning prayer services, do you expect that there would be 40 persons at
I think
165
the
Old Short
number would
Hills Road?
continue to be between 20 and 40, yes.
And what approximately is the square footage of 1 Jefferson compared to 165 Old Short Hills Road? Do you know?
No,
I'll represent to you that I, looked up the house, 1 Jefferson, and it has approximately 7,000 square feet. Does that sound about right to you?
So yeah, you can't provide testimony.
And not only that, I mean, the comparison of the square footage of 1 Jefferson and 165 doesn't give rise to the possible need of any variance relief. It's not particularly relevant to the details of the operations and what's been testified to as to the rabbi's projections.
Agreed, yeah.
Well, the rabbi is, with all due respect, the rabbi has testified as to projections for his proposed use on 165 Old Short Hills Road by comparing some of the uses at 1 Jefferson. I think it's important for the board to know and acknowledge. I think the board can acknowledge that, this proposed building is about 3 times the size of what's operating at 1 Jefferson. So projections based upon 1 Jefferson for a building that's 3 times larger, I think it's important for the board to understand that.
does she have a question?
Your question was, you started giving testimony. I think that was what you started telling how large the existing building is. And I understand you're doing it in the context of asking a question. You had already asked the question, are you aware? Did you use that in? And he answered no, and then you followed up with testimony. So I think that's where the problem is. Once you ask the question, I think we have to go to the next question.
Do you know that?
I just want to remind you that I testified that my numbers projection is not based on the square footage of the proposed building. And my numbers derivation is not based on the square footage of our current space that we're using. So my testimony tonight is that the size of the room that we pray in is completely irrelevant to the number of people who attend. But if you have another question, I'm happy to answer it.
So what is your numbers and your projections that you're giving to the board? What are those based upon if they're not based upon square footage or current operations?
They're based on the people that we interact with, and they're based on our long experience in the township. And I testified last meeting that our congregation has a 40-year plus experience with the township, and people live in the township and surrounding the township. I stand by that.
Would you acknowledge that the building that you're building at 165 Old Short Hills Road that you're proposing to build there is 3 times as large as your existing house on 1 Jefferson?
You're asking the same question repeatedly.
I don't think I ever asked that question.
To be fair, I think that question has basically been asked at this point.
So the witness is not going to answer the question?
Well, I'm saying.
I've answered it, actually. And I've said, and I'll say it again.
Answer.
I know, because you keep going around here. I don't know what you want to say, but I keep saying, because nobody can understand what you're trying to say.
Rabbi, we're going to ask you to answer questions that are asked and not.
My answer is I stand by my statement previously. My numbers are not based on the size of the room that we pray in.
Okay, thank you.
But wouldn't you expect if you build a larger building that more congregants could fit in there and that more persons might come and be expected to use the property?
No,
And why not?
it's an interesting question. I'll tell you what I tell people. There are a number of congregations with very beautiful and large buildings that have closed down recently in the area. I can think of 3 off the top of my head, well established for a long time in the local area in our towns, Livingston, Springfield, and they closed down with beautiful buildings because the size of your building does not guarantee you an attendance. And I will tell you further that there's a beautiful congregation in South Orange that had to merge with another congregation today here in Milburn because they didn't have the people. So the size of the building is very nice, but it does not guarantee you any attendance. If you want to testify or you have somebody who can testify otherwise, I'd be happy to talk to that person. But until you produce a person like that, I can only rely on my own experience. I stand by that testimony. About 6 times already tonight. trying to run the clock out, you're doing a good job.
Rabbi, please do not provide.
With all due respect, I'm trying to go through this as efficiently as possible, and I think I've been interrupted a few times, so.
Thank you. Go to the next question.
Do you expect that you will have congregants coming from other areas to the property, or just that the congregation will serve the local area?
I expect the congregation will continue to serve the local area.
And if you don't think that the congregation, the number of congregants or those attending will increase, then why did the applicant propose to construct such a large building?
Madam Chair, if I may, the size of the proposed building and whether it's larger or smaller or the same size as the existing facility at 1 Jefferson is of very limited relevance. The only time that the size and the square footage of the proposed building comes into play is if it gives rise to the need for a variance with regard to lot coverage or floor area ratio or that sort of thing, which has been examined by the board and its professionals, and it does not. It also comes into play with regard to the trip generation rates and the analysis that the traffic engineers do with regard to what's expected to be generated by way of trips. It's relevant there. All of which has already been delved into and testified to. Beyond that, the continued harping on the size of the proposed facility is not particularly relevant. It might be if we were seeking variance relief with regard to the proposed size. That's not the case. It's relevant with regard to the required number of parking spaces, which we comply with. Other than that, harping on the size of the proposed structure.
Thank you for your objection. Appreciate it. Okay, you have had uninterrupted time of questioning, so we are not trying to dissuade you from asking questions, which you can. You have asked a number of questions, as council mentioned, regarding the size, and as we've heard, it's a compliant application. So yes, the board should obviously consider it, but I think we have taken that into consideration.
Okay, did the applicant consider building a smaller facility at all at any time during the design process?
No,
Do you know approximately how many staff and personnel will be at the 165 Old Short Hills Road facility?
less than 5.
And will that be staff for the House of Worship, the Hebrew School, and the nursery school?
No, the nursery school, I testified last time. Depends on the state requirements for ratio of students per teachers, and that would depend on how many teachers we have and how many students were enrolled, which, I won't know until that happens.
Okay, and just for clarity, I just wanted to confirm, the applicant didn't make any kind of submission related to the number of students that was spoken about at the last hearing, correct? I think Mr.
No, we
can
just heard at the
confirm that.
beginning of this meeting that we will receive it in
Okay.
writing before.
And will the applicant also be submitting to the board at least 10 days before the next meeting revised plans and traffic studies?
I guess we can ask that.
Question
Are
for the
there
applicant.
any anticipated revised plans?
Well,
and
just,
traffic studies?
and we had discussed this, and I say, we had shared with the board those concept plans that were responsive to input and comments from the board and its consultants, and we had shared those in a conceptual way. And then, yes, those concepts need to be implemented in revised plans, which I acknowledged, and yes, those will be submitted. And when the board takes action on those, they will have to have been submitted and on file a minimum of 10 days before the date the board takes action.
Thank you.
Thank you. Are there any other staff other than those 5 staffs for the House of Worship? Are there any security personnel, anything like that?
The number 5 includes security and secretary, myself.
Will there be on-site security personnel?
Probably.
Do you know if there are any particular requirements for security for a House of Worship or a nursery school?
No.
Do you know if the applicant will be complying with guidance from governmental agencies regarding security for houses of worship and schools?
I just testified that I don't know about any such guidance.
Are you aware of any guidance from the Office of Homeland Security
No.
regarding houses of worship? No?
No.
Will there be security cameras on the property?
Our specific security plan is not something I'm comfortable discussing in public.
Okay, will there be a security plan for the facility?
We will have a security plan that again, I don't feel comfortable discussing publicly.
So you wouldn't be sharing that with the board, the
No.
security plan?
No.
And will you be using any type of, or installing any new fencing around the property?
I couldn't answer that question. I don't know. Will we replace a fence? Maybe, I don't know.
I mean, certainly we're not proposing any new fencing that's not shown.
On the site plan?
What will be shown on the final plans.
Thank you.
Would the applicant consider installing new fencing around the perimeter of the property?
No,
Would the applicant consider increasing buffer to adjoining residences
No.
as part of this application?
no.